Thank you for joining us today for this webinar presented by the American Addiction Association in collaboration with Nelson Hardiman. Our topic today is part of our series on regulatory compliance issues relevant to addiction treatment programs is zoning and land use issues for addiction treatment facilities. In this presentation, we'll be discussing navigating the phenomenon of NIMBYism, generally land use laws, and the limitations of siting sober living and addiction treatment facilities in residential communities. As an initial matter, please note that the information we'll discuss today is intended to provide a general guide to certain laws and regulations that apply to addiction treatment facilities. Although we address the issues generally and discuss federal law, it's important to take note of specific state and local laws and regulations in your jurisdiction that may be distinctive. The information discussed is not intended to provide legal advice and should not be relied upon as legal advice. Listening to or watching this video does not create an attorney-client relationship with Nelson Hardiman. We recommend that you seek knowledgeable legal counsel that take account of the local and state laws in your jurisdiction before acting upon the information in this presentation.
So first, we would like to start with an overview of the presentation. In this presentation, we're going to discuss recent zoning battles in California, including the Passages Malibu case, the Newport Coast case, and Solid Landings case. We will discuss and distinguish between licensed and unlicensed facilities. We will discuss federal protections, including the Fair Housing Act, Americans with Disabilities Act, Rehabilitation Act, and the U.S. Constitution. And in the context of these federal protections, we will explain the meaning of disparate treatment and reasonable accommodation. We will also discuss California protections, including the California Constitution, the California Fair Employment and Housing Act, and California Health and Safety Code Section 11834.23. Finally, we will conclude by discussing legislative challenges and local regulations.
So we're going to start with talking about the history of what we call NIMBYism. NIMBYism is an acronym for Not in My Backyard, and it refers generally to opposition from local neighbors to projects, including residential settings for addiction treatment, based on complaints of the impact in the local community. People complain of safety, they complain of damage to property values, and of an additional expense and burden created by residential facilities. The emergence of NIMBYism in the context of addiction treatment began in the late 1970s and 80s as residential settings grew for mental health, for the developmentally disabled, and for people in recovery from substance abuse, as other parts of our behavioral health infrastructure were shut down. And escalating community resistance was a phenomenon seen throughout the United States. There's an important case to which you need to know about when you're thinking about NIMBYism, and that's the Moore versus East Cleveland case. That's a Supreme Court decision from 1977. And from that case until now, federal courts have consistently found that there is no local or state interest in housing and zoning practices that are discriminatory against unrelated housemates. The Supreme Court and federal courts have consistently rejected claims by neighbors that residential treatment facilities and residential sober living facilities, which we're going to talk about, create an adverse effect or have an adverse impact on the residential character of their neighborhood or a financial or administrative burden. And as a result, NIMBYism has historically been contained by the protection of some of the federal laws that we're going to discuss today. The problem is that in the last decade, and particularly since 2010, there has been enormous growth of sober living and residential treatment facilities for addiction. Much of this has been a result of significant changes in federal policy and the Affordable Care Act concerning reimbursement for residential treatment. Some of it has been due simply to a growing recognition of the massive problem of addiction and the need for addiction treatment in the United States. In any case, there is a perception in many parts of the country, and certainly in many parts of California, that the growth of sober living and residential addiction treatment facilities has gotten out of control. And so as a result, we've seen a number of state legislative initiatives and many local municipalities making efforts to exercise more control and put more limits on residential treatment and sober living. And what we're seeing in this wave, as opposed to 30 years ago, is a more nuanced generation of regulatory requirements. That is, we're seeing a generation of municipalities that are cognizant of federal case law and the limits that have been imposed, and are trying to find more subtle ways to limit and control residential facilities. These include things like density and concentration limits, certification and registration requirements, or requirements for accreditation of housing. And we're going to be discussing the legality of those kind of measures today.
So first, we'd like to start with discussing some recent legal battles that are related to the clustering of residential treatment facilities that serve 6 or fewer individuals. And sometimes this is called clustering of 6-packs, which means that it would be a residential facility with 6 residents, serving 6 residents, and then you locate a few of these housing units close together, so they'd be clustering of a 6-pack. One case that we would like to highlight is the Malibu versus Passages case brought in 2015. In that case, the city of Malibu sued the state to force the Department of Healthcare Services to revoke 8 separate licenses held by one operator of facilities located on adjacent properties, and force the owners to apply for a single license covering all 8 buildings. The city objected to the common operation of multiple properties as cumulative non-residential hospital-like use. The court, however, denied the city's relief on showing of insufficient steps by the city to address complaints. Following this case, there has been a shift of the battleground to the legislature, with efforts to enact legislation to give more power to local governments to protect the residential character of neighborhoods against multi-site operators.
So just to comment on this, we're going to talk more today about the more or less absolute protection that exists under federal law and in California under state law for licensed residential treatment if there are 6 or fewer residents in treatment in a particular facility. This phenomenon has really become a front-line battle for the future of state legislation. This is an issue not only in California but in other parts of the country. So anyone thinking about using a clustering model of putting 6 or fewer residences adjacent or in close proximity should be mindful that legislation has been attempted. AB 2403 is the most recent California bill that was considered in the past legislative session, and it's an issue that is expected to return not only in California but in other states as local communities make the claim to the state that the allowance for an unlimited number of 6 or fewer properties potentially allows for very significant operations to be permitted without any oversight at the local level. So another recent legal battle in California that's interesting to highlight is the Newport Coast Recovery case. In this case, there was a 7-year legal battle between the city of Newport Beach and several residential treatment facilities, including Newport Coast Recovery, Yellowstone Women's First Step House, and Pacific Shores Properties. And essentially, in this case, the city had imposed numerous sober living restrictions, including a quiet hours requirement, parking limitations, smoking areas and that's designated, and even specific van routes that the sober living homes were supposed to use in taking their clients to outpatient treatment programs. And this was a case where the city ultimately was forced to pay over $5 million to these sober living operators and had spent an additional $4 million or so litigating. The Ninth Circuit Court of Appeals had ruled in favor of the group homes, and this was a significant victory for sober living operators in the fight against excessive local regulation that was discriminatory. By contrast, it's also interesting to look at the recent battle of Solid Landings Behavioral Health versus Costa Mesa. This was a case where Solid Landings, also an operator of sober living homes, sued the city of Costa Mesa over denial of zoning approval for outpatient operation, for imposition of 650-foot spacing requirement between sober living homes and good neighbor standards. Initially, an injunction was issued by the Ninth Circuit against the City of Costa Mesa's ordinance, but in April 2016, Solid Landing settled with Costa Mesa in a settlement that agreed to close 33 sober living facilities in the city. It's important to note that this case, that Solid Landing's settlement and its decision to close the facilities appears to have been driven by independent business reasons and a significant downturn in their business rather than based on any legal theory. At the same time, when you contrast the Newport case and the Costa Mesa case, it highlights that that some of these cases turn out to be victories for sober living operators and others not so, and that there's a complex battle being waged that has many variables, including the business success or lack thereof in the case of the Solid Landings case.
Next, we're going to discuss licensed and unlicensed facilities. In California, residential alcohol and drug treatment facilities are required to be licensed by the state. The California Department of Healthcare Services licenses 24-hour adult, residential, non-medical alcohol and drug recovery and treatment facilities that provide treatment services. Treatment services include non-medical detox services, group, individual, or educational sessions, recovery or treatment planning, and other types of individualized services. Additionally, residential treatment facilities may apply for an optional certification from the California Department of Healthcare Services or an optional accreditation by CARF or the Joint Commission. We would like to note that insurance companies have increasingly been requiring an optional certification or an accreditation for reimbursement for services. Additionally, there are other related categories of licensure for which a facility may apply, such as a teen group home, and that's licensed by the California Department of Social Services, or a social rehabilitation facility, and that's also licensed by the California Department of Social Services, or a congregate living health facility, and that one is licensed by the California Department of Public Health. In California, the state does not license facilities known as sober living facilities, transitional housing, or extended care facilities that provide substance-free housing and living arrangements. These types of arrangements are limited to hotel services and house meetings. They may not include any treatment services, and none of the services provided at a sober living house or other non-licensed living facility are reimbursable by insurance. Also, the California Department of Healthcare Services does not offer licensure for outpatient facilities. DHCS only offers an optional certification for outpatient facilities in California. And again, as we mentioned, the insurance companies have increasingly been requiring an optional certification or accreditation for reimbursement of services. We would like to highlight that one common model we encounter in our practice is sometimes referred to as the Florida model. And this is where a company runs an unlicensed residential facility, such as a sober living house, and an outpatient facility at the same time. And the California regulators view this type of model as an illegal circumvention of licensure.
So this is also, as with the question of clustering, the operation of sober living and outpatient by a single operator or by related companies is an issue that's on the horizon for legislative action and for further regulation. This is a very confusing area in which we're frequently asked questions about where the line is. It's clear that the Department of Healthcare Services is offended by what they call the operation of an integral facility, and basically just getting around the need to license a residential treatment facility by using sober living unlicensed and taking people every day to an outpatient program. At the same time, there does seem to be recognition that there is an appropriate place for sober or transitional living, and that often in the process of recovery from addiction, there's a natural progression from a more intensive setting, such as a residential treatment setting, to a more independent setting, like a sober or substance-free housing arrangement. So there's a lot of clarification remaining to be provided ahead, and anyone who's operating in this model should be following it closely and consulting with counsel. So we wanted to turn to some of the federal legal protections that we mentioned earlier that have driven the law in the Supreme Court and federal case law decisions. So with federal law, we begin with the U.S. Constitution and the Equal Protection Clause of the 14th Amendment, which prohibits states and local governments from denying any person the equal protection of the laws. In the 1985 Supreme Court decision of City of Cleburne versus Cleburne Living Center, the Supreme Court held that local officials are required to treat individuals who are similarly situated in the same manner. And in that case, a local zoning ordinance had been imposed that required group homes for people with developmental disabilities and mental illnesses, as well as recovery addiction treatment homes to obtain a special use permit as a condition of opening group homes. And the Supreme Court struck this local ordinance down, finding that it reflected a prejudice against a protected class of the disabled under the guise of protecting legitimate city interests. And again, this is really a classic, an important case to understand when you're dealing with the phenomenon of NIMBYism, negative attitudes and fears of people who are different, fears of unrelated people living in residential communities, people who are in recovery from addiction are pervasive. And what this case and what the Equal Protection Clause stands for is the principle that local governments don't have the right to treat individuals differently simply because they're not related to one another or because they happen to be in recovery from addiction. They have to be treated like everybody else in that neighborhood. Now we turn from the Constitution to specific federal laws, federal statutes that address the issue. And the first one that's important to understand is the Federal Fair Housing Act, which prohibits the denial of housing to certain kinds of protected classes, including groups of disabled person. So since the 1988 amendments to the Fair Housing Act, a person in recovery from addiction to drugs and alcohol is officially considered to be part of a protected group. And that 1988 amendment to the Fair Housing Act is a significant brick in the wall of federal protection for residential treatment and sober living facilities, and a limitation on state and local governments in attempting to impose special restrictions upon addiction treatment facilities. The other important federal laws to understand are the Americans with Disabilities Act and the Rehabilitation Act. So the ADA, the Americans with Disabilities Act, was enacted in 1994, and Title II of the ADA prohibits state and local governments from discriminating against the disabled in municipal zoning decisions. And here too, under the ADA, alcoholism and drug addiction facilities are protected because alcoholism and drug addiction are recognized to be disabilities under the Americans with Disabilities Act that are no different than any other kind of disability. You typically will hear less discussion of the Rehabilitation Act, which is another law against discrimination in housing. But we point out also that Section 504 of the Rehabilitation Act is yet another federal law that also echoes this same policy of protecting the recovery community from discrimination with respect to housing.
In addition to the laws, there are a few important concepts that we would like to discuss. One of those is disparate treatment. Disparate treatment means requiring something of a sober living residence or residential treatment facility that is not required of other residences. This means that a residence of 6 or fewer people cannot be subjected to any legal requirements that wouldn't also apply to a family living in the residence. For example, disparate treatment would include requiring a sober living facility to obtain a permit when such a requirement is not required for other families or individuals living in a single-family residence. This type of requirement amounts to treating handicapped individuals differently from other individuals living in a single-family dwelling, and so that is what is considered disparate treatment. It also includes requiring business taxes, local registration fees, use permit fees, or other types of fees to be paid by the sober living facility or residential treatment facility of 6 or fewer, but not by other single-family dwellings. We'd like to note that local property taxes, water, garbage collection, fees for inspections, and other types of fees like this are not prohibited as long as the same fees are required for single-family dwellings.
And just to think about this on the simplest level, the basic concept that the Fair Housing Act, ADA, and all the other federal legal protections embody is that local governments have no right to treat residences when they have 6 or fewer any differently than neighbors. And if you're wondering why 6 is the number, that was understood to be a level of density within a particular residence that was traditional. So when you get into family residences, homes that can accommodate more than 6 people, you do get into a more complicated analysis, simply because this was the number at the time that these laws were passed that was seen as a size of dwelling a size of family that could be accommodated by any dwelling.
Another important concept that we would like to discuss is reasonable accommodation. Reasonable accommodation means that to the extent zoning or land use approval is needed, for example, residential facilities serving more than 6 clients, local governments have an affirmative duty to provide reasonable accommodation or flexibility when making decisions regarding housing for persons with disabilities. Reasonable accommodation applies to any activity that would require any applicant to obtain a zoning permit or local land use permit, for example, a conditional use permit or variance. Please be aware that residences exceeding 6 clients may require a conditional use permit or variance. They may require fire safety clearance from the local fire marshal or other authority, and application fees may be required to obtain that fire safety clearance. There may also be water safety requirements and certain requirements that apply to construction. For example, if you want to expand, renovate, or add something like ramps. And there also may be additional requirements that apply if you're in a commercial area. Facilities with multi-site operations may be required to comply with other commercial local regulation. For example, the health department has regulations regarding providing a centralized food service. Please be aware that obtaining a variance or conditional use permit often includes notice to neighbors and a hearing process, and this is something that you want to consider if you're going to be applying for a conditional use permit or variance.
So disparate treatment and reasonable accommodation are essentially 2 sides of the coin. As a addiction treatment facility dealing with demands from a local government, it's ideal to be in a situation where you can assert your right not to be treated differently. But there are going to be some cases where cities are rightfully entitled to demand that residential treatment facilities go through conditional use permitting and hearing processes and establish a right to reasonable accommodation. It's important to understand and make sure that you are on the right side of this equation. And frankly, this is a constant issue that comes up in disputes about whether there's a absolute right not to have particular restrictions imposed under a disparate treatment standard, or alternatively, whether it's necessary to articulate and justify a reasonable accommodation standard, which gives local governments an opportunity to impose their oversight. So having completed the federal legal overview, we wanted to turn to some specific California issues. California, we start again with the Constitution as we did with the federal Constitution. There's a significant difference between the California Constitution and the U.S. Constitution that California facilities should be aware of. Specifically, in 1972, California voters adopted by referendum an express state right to privacy. And the California Supreme Court has, since that vote, has found that the right to privacy includes the right to be left alone in our own homes and the right to choose with whom to live, including the right to live with unrelated people. And based on this provision in the California Constitution, California courts have struck down local ordinances that attempt to control who lives in a particular house whether they are a traditional family or unrelated, whether they are people in good health or they are disabled, which includes being in recovery from addiction, and whether they are renters or owners. So it's important to note that this is a completely different strand of protection. This right to privacy is a very different strand of protection from the right to be free from discriminatory housing practices that we've been discussing under federal law. And there's an opportunity to assert additional rights and a completely different legal theory that protects addiction treatment facilities. We want to turn now to California's laws and start with the FEHA, the Fair Housing Employment and Housing Act. This is the broad California law that prohibits both intentional discrimination and zoning rules and regulations that may be neutral on their face but have the impact of discriminating against people with disabilities, including land use practices that discriminate against group living arrangements and including discrimination against people in recovery from addiction. Now, California has historically construed FEHA very liberally for the benefit of protected classes and has essentially interpreted the Fair Employment and Housing Act to be in accordance with the Fair Housing Act, which we discussed earlier, and to view that as a minimum level of protection that may actually be heightened by FEHA. So FEHA prohibits unlawful housing discrimination, including denials of conditional use permits and other refusals by local governments to make reasonable accommodations in rules or policies needed to afford a disabled person equal opportunity to use and enjoy a dwelling. The way that this may come up is that if you are an addiction treatment facility that has gone through a conditional use permit process seeking reasonable accommodation, and you believe that you have been treated unfairly, or if you have been subjected to a local law that somehow blocks a reasonable accommodation, you may have a claim under the law for a violation of FEHA. And again, in California, recovery from addiction is understood to be a protected class of disability entitled to the benefit of therapeutic and supportive living environment.
California state law also offers protections to individuals living in residential treatment facilities and sober living homes. The California Health and Safety Code section 11834.23 provides protections for 6 or fewer residents. It states that an alcoholism or drug abuse recovery or treatment facility that serves 6 or fewer persons must be treated like a single-family residence for the purposes of any law or zoning ordinance that relates to the residential use of the property. It also states that a recovery or treatment facility with 6 or fewer persons shall be considered a residential use of the property, and states that no conditional use permit, zoning variance, or other zoning clearance shall be required for a facility that is not required of a single-family residence in the same zone. California state law preempts municipalities from using zoning and other local ordinances to restrict access to residential facilities.
Now, one of the questions that comes up around Health and Safety Code 11834.23 is whether it only protects residential treatment facilities licensed by the Department of Health Care Services, or whether it also protects unlicensed sober livings. And we note the definition of alcohol or drug abuse recovery or treatment facility as any place that offers residential non-medical services. The reason that we highlight this is because in a number of disputes with local municipalities, they have made the case that this description of non-medical services describes the scope of practice of licensed residential treatment facilities. And that's an argument. It's not, frankly, it's not established clearly in the law whether 11834.23 only protects licensed residential treatment facilities or also protects sober living facilities, as we have argued in the past. It's clear, in any case, if you are an unlicensed sober living facility, that there is no argument that you are protected by federal law, irrespective of the position that municipalities may take concerning the health and safety code provisions that we've discussed. And we've included an example of a federal citation that makes that clear. And what we're going to turn to in the next part of the presentation is some of the ways in which California has been, and at a state level and at the local community level, have been exploring ways to regulate sober living in spite of all of the legal protections that we've discussed. And California is on the brink of being the latest state to consider a state-level regulation of sober living facilities.
And before we get to that legislative discussion of legislative solutions, we wanted to discuss that we are also frequently asked about private homeowner associations and whether they can prohibit residential facilities from operating. Generally, if you're part of an HOA, you agree to follow a set of special rules through deed covenants and contracts. And California law requires any contract, deed, or covenant for the transfer of real property to treat an alcoholism or drug abuse recovery or treatment facility with 6 or fewer residents as a residential use of property and a use of property by a single family. Thus, it is legally permissible to operate, but practically, if the HOA is against your operation, this is going to be a potential recipe for expense and trouble. Issues that arise between residential treatment facilities and HOAs are commonly resolved after litigation for voluntary good neighbor restrictions. For example, installing alarms, cameras, having noise, parking, and other types of restrictions.
And again, we're not endorsing these as a solution, but merely describing a frequent phenomenon of the conflict between residential treatment or sober living facilities and homeowners associations. Okay, so we wanted to talk about some of the legislative solutions to the conflict occurring between residential communities and addiction treatment facilities that were discussed and under consideration in the most recent legislative session. The first was the issue of voluntary certification processes for sober living. Last year, several states, including Florida and Massachusetts, established voluntary certification processes for sober living homes. In Florida and Massachusetts, those voluntary certification processes take effect in July of 2016. California, AB 2255, proposed to add the same optional certification standards in the state of California. And again, this was an optional, not a required certification for sober livings that wanted to be officially designated as drug and alcohol-free residences. The requirements to receive the optional certification included enforcing a sober lifestyle for all residents, including live-in managers, operators, and owners, active participation by sober living home residents in legitimate programs of recovery for substance use disorder, including by specific reference Alcoholics Anonymous. When available, continued use by residents of ongoing outpatient treatment, aftercare, or other recovery maintenance systems in accordance with a clinically managed system of care if one exists for the residents. And also a zero tolerance policy towards possession or consumption of alcohol or controlled substances, except when used in a manner consistent with a prescription. Again, not only by residents, but also by owner-operators and by managers. So AB 2255 also included good neighbor policies to address neighbor concerns and complaints, mandatory home policies on how to handle relapses, how to handle evictions, and emergency planning. And the Department of Healthcare Services was going to maintain an online registry of sober living certification status and a disciplinary record for certified homes that had problems. Again, as I noted, it does not. This is an optional certification program. It's interesting to note that the certification was not going to come from the Department of Healthcare Services, but would be delegated to an approved certifying organization, which in turn would set up an application process, certification standards, including annual inspections, and a disciplinary process for investigations and enforcement actions. Many in the sober living community support AB 2255 because it establishes a framework for good practices and because there has been recognition of problems in the sober living community and a lack of standards. We believe that this kind of certification is likely to expand across the country and is something that sober living operators should be mindful of, even though it is not yet and may never be a formal requirement. Now, we wanted to turn to some of the other legislative initiatives And the first one that's interesting to note, even though it did not succeed in the current legislative term, was California Senate Bill 1283. 1283 was proposing to authorize local communities, cities and counties, to regulate sober living via a mandatory registration process. And this was essentially going to be a state authorization for each local community to require sober living owners and landlords to register, to provide their name, address, contact information, and their leases, so that the local community knew exactly what facilities were being used as sober living. At the current time, there is no, in most communities, there are no such requirements. The law was also going to authorize cities and counties to establish in-home supervision requirements for essentially 24/7 management, and to require that sober living homes establish and maintain operational plans to facilitate rehabilitation, including discharge planning, and address property maintenance and noise abatement consistent with local standards, and of course to obey all kinds of health and safety standards and enforcement mechanisms. So frankly, as advocates for sober living and addiction treatment facilities, we were very concerned by these requirements, which are completely at odds with the principle of disparate treatment that we indicated earlier. And so we were relieved to note that SB 1283 failed to pass and appears to be dead in the current legislative session. But we expect this issue to be revisited at the state level, and as we'll discuss on the future slides, this is actually an issue that's going to move forward on a more practical level as cities and counties elect on their own to impose these kind of requirements. And that's what we've listed on this slide. Essentially, even though 1283 did not pass, as a practical matter, if a review of cities around California reflects that a growing number of cities are experimenting with a wide range of economic and non-economic restrictions on sober living homes. These include registration certification requirements, ownership disclosures, density and restrictions like the 650-foot spacing limit and often slightly lower levels at which sober living homes are required to be spaced from each other, operational requirements including a proof of insurance, posting of rules and regulations, policies and procedures and on things like discharge planning, property maintenance and noise abatement, filing of reports, payment of taxes, transient taxes, 24/7 supervision requirements, and active participation by residents in recovery programs during their stay. And again, turning back to the earlier part of our program, we have serious concerns about these measures. Frankly, they appear in many cases to be a sort of new generation of NIMBYism and a creeping attempt to impose different rules on sober living homes based on claims of issues of safety and essentially neighborhood problems. And there are many communities around California that have already adopted these ordinances, and sober living and addiction treatment facilities in these communities may be forced to go to court or be forced into litigation by cities in order to validate their rights under the federal laws that we've discussed as a result of these laws.
So, if you take away anything from this presentation, we would like you to remember the following. It is critical for operators to understand established federal and state legal rights. Many local ordinances may be unconstitutional, but you still may have to expend time and money and effort to enforce your rights, and this may require a fight with your local municipality. Discretion is the better part of valor. There is a value of practicality, negotiated resolutions, and avoidance of disputes. Also, there is uncertainty ahead, as Harry was discussing, on the right to regulate aggregated operations and reasonable spacing requirements. There is an outstanding question of whether legislatures will react to the rampant growth of residential treatment facilities and whether we will see further federal legal challenges and a more nuanced position on local regulation. And finally, our prediction is that there will be more active state regulation by the Department of Healthcare Services in California and probably across the United States.
As a final note, we're in a very critical time in the development of law, both at the local and state level, and it's never been more important for operators to be mindful of the legal environment and of their rights. And we hope that this presentation has been helpful in providing an overview and a starting point. We want to thank you for listening today, and if you're listening to this program before July 27th and happen to be in Southern California, please check out the AATA website at addiction-tx.com for a program being held on this very issue on July 27th. We look forward in the future to additional programs to delve more deeply into some of the specifics of issues like clustering and density restrictions and the other issues that we discussed on this program. Thank you very much.